Welcome to CAN Camp number 2. My name's Jeannie Gordon and I'm the Legal Issues Training Coordinator for the Children's Division. Today's date is September 13th, 2011. The materials for this training are available on the Children's Division intranet. You'll go to Legal Aspects DVD series and you can download them from there. The assumption for this training is that you've had the legal aspects for investigators and supervisors training and that you've also done CAN Camp number 1. Let's start with the index page. The second slide is an index page which gives you an idea of what the training is going to be about today. We're going to talk about elements analysis, physical abuse, emotional abuse, neglect, those responsible for care, custody, and control. We're going to talk about weighing evidence, and we're going to talk about potpourri. And potpourri is just kind of a catch-all that has a little bit of everything in it that I thought would be of interest to you and would help with your investigations. Each of these topics is a separate chapter on the DVD for your convenience. So as far as the goals of the training are concerned, the idea today is we're going to look at circuit court cases and how the court views the legal aspects of the elements of abuse and neglect, and how the court looks at weighing evidence for preponderance of the evidence. The good news is we are doing fairly well, very well in fact, at the CAN-RB, and as a result I can use examples of good cases where we have been upheld. And that most of these cases that have been upheld at the CAN-RB and then gone to circuit court, we will be upheld in these cases. There's a few we won't, but most of them that we will. So let's start first with the elements analysis, and we'll begin with physical abuse. Abuse is any physical injury, sexual abuse, or emotional abuse inflicted on a child, that's the second element, other than by accidental means, which is the third element, by someone responsible for the child's care, custody, and control. And then the fifth element, we can't forget that except for discipline, if it's administered reasonably, shall not be construed as abuse. And the only thing I want to talk about as it goes to the 5 elements is just remember that it's really important to connect the dots between the act of the person responsible for care, custody, and control, and that they are the one that inflicted the injury. You want to make sure that you rule out it could have been someone else who fits that definition of care, custody, and control that could have caused the injury. You also want to rule out the other than by accidental means. So a very good tip, a very good idea is to be sure whenever possible, take the parent through the weekend. Tell us about what the child did all weekend. Take the child through the weekend. Tell me about what you did all weekend. You can talk about the various activities that the child had that might have resulted in some sort of accidental injury. And you can also then talk about who else beside the parent might have been there that could have been responsible for care, custody, and control. So those are 2 very important pieces that we want to be sure to remember when we're doing investigations. So the next thing we're going to do is we're going to start with activity number 1, because we talked today that we're going to look at circuit court cases. We're going to talk about a physical abuse case involving mental illness. So this was a circuit court case for de novo judicial review, which meant it was upheld at the CAN Review Board. So what you need to do is read the judgment and find the 5 elements of abuse. Then discuss with those that you're taking this training with, what is the court's reasoning on number 1, the element of physical abuse, and number 2, other than by accidental means. So at this point we will stop the tape and give you time to read the case and discuss it. All right, let's pick up activity number 1. You've had a chance to read it and discuss it. We talked about how this case makes the 5 elements of abuse, and then we were looking at other than by accidental means and how mother's mental illness plays into all of this. I think, unfortunately, one of the saddest things about the work we do is a parent's mental illness or drug use are the underlying causes of abuse or neglect. We see this quite a bit. This case, I think, illustrates 3 things. Number 1, mental illness does not excuse abuse in a hotline investigation. Again, you have to remember, what is the purpose of the hotline investigation? It's to put someone's name on the registry for abuse or neglect to protect children. It's a sad case when you have to do that to protect their own children from mental illness. Secondly, mental illness does not mean it was accidental. Just because a parent doesn't take their medication or is decompensating does not give them the excuse to say, well, it was accidental. And we're looking particularly at the element of other than by accidental means. And thirdly, I think the way the court talked about inflicting an injury on the child in a non-accidental manner, which, again, we're talking about that element of other than by accidental means. So in the findings of facts, conclusion of law, and judgment, again, to make this easy to read, we edited out some information clearly. But mother was a resident of the county. She had a child and a sibling, and the child is the one who was abused. The evidence that the court found as fact was that mother had a history of mental illness. Specifically, she testified she was diagnosed with depression, anxiety, and obsessive-compulsive disorder. There was also some evidence that she experiences delusions consistent with mental illness. The court made other findings based on all the other people that testified in the case. What was particularly interesting, I think, in paragraph 4 was that it was just, when the child was seen that night, the child had a bruise on the side of his face that was approximately 1/2 inch by 2 inches. So you've got a good description of the bruise. We know the age of the child. The child was 5 years and 2 months old on that date. And the other very important thing is that child and mother were the only persons present in the residence on that evening when the incident took place. When you look at paragraph number 5, the court finds that the investigator's testimony was credible. That means the court found the investigator testified very well and was very believable. And I think that is very, very important in these findings when we hit the court cases. So again, the court finds that the investigator observed a purple bruise on the child's face that was 1/2 inch by 2 inches. The investigator testified that the injury was prominent. And again, we have the investigator having talked to the child where the child said that mother had swung him around and caused him to hit his head on an unknown object. That was the child's version of what happened. Clearly, the investigator also talked to the mother, who mentioned that she had injured the child by striking him with an open hand 4 or 5 times. So now we have 2 different versions of what happened to the child and how the child was injured. Mother also told the investigators that she had not been on her medication for her mental illness during that week. At trial, mother provided a different version of what happened and testified that she had injured the side of the child's face by hitting him several times with a flip-flop sandal. Mother denied that she'd told the worker she'd hit him with her hand 4 or 5 times, but later admitted she had mentioned that to another worker. So the court made conclusions of law that I thought were pretty important. If you look at the 3rd paragraph in the conclusion of law, the court finds that mother is the biological parent of the child. So we're getting at that care, custody, and control piece, and was responsible for care, custody, and control on that evening. The child and mother were alone in the residence on that evening. Mother, therefore, was exercising supervision over the child, who was 5 years old at the time. Mother was responsible for care, custody, and control. When it comes down to how the injury happened, the court in this particular case really says it doesn't matter which way it happened. All 3 stories are consistent with how that injury could have happened to the child. So regardless of which story it is, which one is true, everyone offered explains how the child's face was injured meets the statutory definition of abuse. The court also made a note that mother had a mental illness that likely contributed to her abusive treatment of the child. And that's true, we realize that. But the court says that does not make her actions accidental. Really what's important is while there certainly was evidence that mother was responding in part to mental illness, it is her actions that constitute abuse rather than her motivation. I thought that was very important. So at the end, the court finds, after de novo judicial review and by a preponderance of evidence, that mother did physically abuse the minor child and was responsible for care, custody, and control. And the court found that mother's name should remain as a perpetrator on the registry. So when it comes down to our 5 elements of abuse, we have physical injury, because we have a bruise that's 1/2 inch by 2 inches and is purple in color on the side of the child's face. The child is 5 years old and 2 months, so he's under 18 years of age. Was it other than by accidental means? Yes, it was, because whether she struck him with her hand 4 or 5 times, whether she hit him with a flip-flop sandal 4 or 5 times, or whether she actually swung him around and he hit some unknown object, it was still other than by accidental means. Those were intentional actions on her part. Was she responsible for care, custody, and control? Yes, she meets the legal definition just because she's a parent. But the really great thing in this particular case is the investigator ruled out that there was anyone present in the home that particular evening that this event happened. So obviously mom had care, custody, and control besides just being a parent. And then the discipline was not reasonably administered, whether it's slapping in the face, hitting with a flip-flop, or swinging a child around. So lastly, other than by accidental means, mother inflicted the injury on the child in a non-accidental manner, whichever method it was that she used in this particular case. So this is a good illustration of a lot of what we see, I think, in investigations and assessments when we're dealing with a parent with mental illness. Let's move on now to slide number 8, and we're going to talk about an appellate court case called SEMA versus Fansler, which is a Western District Court of Appeals case from 2011. We've seen some of these kind of cases before. We saw State versus Moran, which was a child order protection case in which the court talked about abuse and what the definition was, and it gave us a definition for emotional abuse. In this particular case, we're going to talk about physical injury to the child, and other than by accidental means. And this came out of this child order protection case. So child order protections, at least until this August, the definition of abuse was very, very similar to ours. The only difference was in responsible for care, custody, and control. While we required responsible for care, custody, and control, under the child order protection, it had to be an adult household member, was who the person would be. So in this particular case, the court found that Fansler, who is father's paramour, inflicted physical injury on the child under circumstances that did not involve an accident or reasonable discipline. So that's how they talked about that element of other than by accidental means and the discipline exception, which is element number 5. So those are elements 4 and 5. So in this particular case, I think it illustrates, number 1, documenting the injuries by photos and descriptions. I think those are very important. Also, how long did the bruising last? I think that's an important question to know. Also, another question would be asking questions about the pain the child is experiencing. And thirdly, lastly, documenting how long the pain continues. So we've got documenting the injury with photos and descriptions and how long the bruising lasts. Ask the question about pain. How long did the child experience pain? If the child experienced any at all. Sometimes the bruising is not going to cause a lot of pain. And thirdly, documenting how long the pain continues. So in this particular case, you've got significant bruising and pain, and we have good descriptions. So the facts of the case, I think we're on slide number 7. The child had 2-inch red marks across his back and bottom. They were observed by the worker, by law enforcement, and they were photographed. Yay, yay. The child was 6 years old. He was coming back from dad and girlfriend's house to mother's. So mother sees bruising on his lower back, all over his bottom, and the child cried because it hurt when he pooped. The child tells law enforcement the dad's girlfriend spanked him with a spoon with a hole in it. Girlfriend admitted to the spanking and had used the plastic spoon in the past on the children. the investigator sees significant bruising. So we're not talking just a little bit of bruising. We're talking significant bruising across the lower back and all over the bottom. Particularly, the investigator saw 2 parallel bruises across the child's bottom. So we have the child returning to mother's house with substantial bruising. The child was still in pain for more than 24 hours. That's what this particular case says. And the bruising remained starkly visible for at least 48 hours after spanking. Now, this is an appellate court case, so it's the court that's making the decision that they were starkly visible. So starkly is kind of an opinion, but you want to talk about how clearly visible they were at the 24-hour mark and remain so at the 48-hour mark. When we talk about the element of physical injury in this particular case, what the court said was the testimony regarding the child's complaints of pain and the extent of his photographed bruises were sufficient to prove that the child suffered physical injury as a result of the spanking. So we've got a statement from the court that says that. As to whether or not the spanking was reasonable discipline, the fact that the court says the fact that the child continued to suffer pain and had obvious signs of bruising for more than 24 hours also supports a finding that the spanking was not done in a reasonable manner. I would go further than that based on this case because it also talks about they were starkly visible at 48 hours. So in cases where you can show that the child remains in pain a couple of days past the time of the injuries were inflicted and that the bruises are still very visible, I think that helps support your case that there was physical injury and that it was not discipline administered in a reasonable manner. Okay, now we're going to move on to slide 13 and we're going to talk about emotional abuse. This is in policy. This is in the reaching the conclusion part of the policy. The name of the case is State versus Moran, M-O-R-A-N. And again, the policy and the law on this comes from a child order of protection. So when we talk about injury to the child's psychological capacity or emotional stability, then what we need is for it to be demonstrated by an observable or substantial change in the child's behavior, emotional response, or cognition. So just hang with me on this, and then I'll give you the facts of the case. This would include, at a minimum, anxiety, depression, withdrawal, or aggressive behaviors. So the idea is that the caretaker causes injury to the child, psychological capacity or emotional stability, and you connect that to the changes in the child's behavior. On slide 14, you'll note that you still have to meet all the other elements of abuse, but for now we're just talking about the element of emotional abuse, which is injury to the child. So in State versus Moran, what you had was some grandparents that were legal guardians of the child, and mother was in prison. They knew mother was getting out of prison and were very concerned for the welfare of the children, so they went to court and got a child order of protection. Now remember, because they're legal guardians, they have the ability to get a child order of protection on behalf of these children. So it's a small boy and girl, in the 7 to 9-year-old range. So mother gets out of prison and starts coming around and sees the child out riding his bicycle, and she's not supposed to be having any contact with the child. And what she does is she starts talking to him and saying, I filed something in court, I'm going to get custody of you back, and starts threatening the child. And it scares the child pretty badly, which is the younger boy. And he goes home to the grandmother's house, comes in the house. He's obviously upset. He's very quiet. Grandma notices this, asks him what's wrong, and he won't tell her what's wrong. And then he goes to his room. It turns out this behavior continued with this child on more than one occasion, and also with the daughter who was a couple years older. And eventually mom got to the point where she was telling them she would kill them if they repeated the information or that she was telling them these things. So what grandma observed with the child is that he was visibly upset. After that, he kind of stopped eating. He kind of withdrew into himself. He was very quiet. He seemed a little depressed. He was isolated. And then he would have bouts where he would get angry and aggressive at times. And the court allowed grandmother to testify to that and said that that was enough to show that there was an emotional injury to the child because grandma could connect the what had happened to the children, to the changes in this particular child's behavior. So the court said that meets the definition of abuse for purposes of a child order of protection. And like I had said earlier, that matched up with our definition pretty much for abuse. There's one part of that, if you'll take a look at slide 15, a mental health provider is no longer required based on this case then. So policy has changed. A mental health provider is no longer required. However, it's probably still best practice. And maybe we should take a minute and discuss why. Think about it. Some of our relatives who have custody of children or who observe the behaviors of the children will have some biases in what they're going to tell the court and why. They may want custody of the child. They may have something that they want to get even with the parent on. They may have their own agenda for why they're willing to say the things they're willing to say. So I think we have to be very careful when we're using another parent or we're using relatives to connect the dots between the actions of the parent and the injury to the child. A mental health provider will always be a better bet, number one, because they should be unbiased. They should not have an axe to grind in the particular case, and therefore what they would testify to would be their professional opinion. And again, they have the additional training necessary. They are more of a neutral person and would be best to be the one that is able to say that. So that's just a recommendation when it comes to emotional abuse. Let's now move on to slide 16, which is neglect. So we're looking at the legal definition of neglect. It comes in 3 parts. You can read the definition. Anybody who's been to the training that I do knows that what I think is important is to remember what was the parent supposed to provide and what did they fail to provide. And that you need facts and an explanation for what it is that they're supposed to provide and how they failed. And a lot of our codings will match up with that and help give you the explanation that you need. All right, before we go on to activity 2, I would like to talk about a case that I think helps illustrate what was supposed to be provided and what was failed to be provided. This is a case where a child had diabetes. The child was 10 years old. Mom had care, custody, and control of the child at all times during which the events took place. And what the case began as an assessment, untreated illness or injury, and it was upgraded to an investigation. And based on the facts of this particular case, the child was actually removed and placed in protective custody. So how is the coding untreated illness or injury neglect? Again, we're looking at what is the parent supposed to provide. With a child who has diabetes, I think which is a medical condition, I think you can say the parent is supposed to provide the necessary medical treatment or intervention to remedy or ameliorate a medical condition which is life-threatening or causes injury. And that matches up with one of our codings on untreated illness or injury. And in this case, what did the parent fail to provide? The parent failed to control and manage a 10-year-old's medical condition, placing him at high risk of harm, the potential for death, lost eyesight, or lost limbs. So I think that one's pretty clear. So let's talk about how the conclusion was made. I'm going to read to you how the parent failed to provide for the needs of the child, how this investigation was concluded. Mother failed to provide for child's medical needs necessary to his well-being. I thought that was very good. The child had a diagnosis of insulin-dependent diabetes mellitus. The child's condition requires daily monitoring of blood sugars, insulin dose, and diet. The child had had this for several years, since 2007. The child had been treated on an outpatient basis and had been hospitalized several times as a result of blood sugars consistently being in the high ranges. The child's primary care physician, the endocrinologist, and other medical professionals stated that the child's condition was in poor control and that he was at risk of losing limbs, permanent damage to vital organs, and possible death. Mother was offered many support services, including diabetes education and case management, which she refused to participate in. Mother reported she was allowing the child to monitor his own blood sugar. The doctors had informed Mother that he was not mature enough or old enough to take on responsibility independently. However, she continued anyway. Mother did not monitor his food take. Mother admitted to allowing him to eat candy bars, drink Mountain Dew, and consume foods that she knew would make it difficult to correctly measure his insulin. So I think very clearly this was a very well-written conclusion on neglect. And there are a lot of facts in the investigation itself as to the numbers of his A1C, how long this had gone on, and other statements by the various doctors about how serious it was. So again, what was the parent supposed to provide, and what did they fail to provide? This is a great example, and I believe this one came out of Greene County. So at this time, let's take a look at activity number 2. This is a 2010 de novo judicial review case in circuit court. So we want you to read the summary of the investigation. The CANRB upheld it, and a petition was filed at the circuit court for a de novo judicial review. The question to you is, would you be the judge, and would you find that mother neglected her 4 children such that her name should remain on the central registry? At this time, we will pause to give you time to read the case and discuss it with the members that you are taking this training with. So what did you think of activity number 2? Obviously, there were some problems here. The child was 11, was physically abused by mother's live-in boyfriend. There were extensive bruising. There's no question he was actually convicted for endangering the welfare of a child. One older sibling was present at the home at the time of the abuse. The mother and the other 2 siblings were not. One of the problems with the case, I think, is that even though there'd been an assault by the boyfriend on mother, and there'd been a case brought in the adult order protection case, there had never been any evidence that he had done any assaulting or any type of physical acts towards any of the children prior to this. So what was clear is neither the mother nor the children's division were on notice that he would do this to any of the children. And in opposition to that, he had been sober and compliant with the terms of his probation since his return to the home with the mother and her 4 children. So what did mother do when she first found out about the boyfriends having abused the child? She took immediate steps to protect that child, confronted the boyfriend, securing an agreement that he would not physically abuse them, and eventually removed the boyfriend from the house at the direction of the JO and CD. However, things went a little bit awry, and the children were taken into protective custody by law enforcement. There was some dog feces on the floor in the home. Only the 2 older children were home. What eventually happened from that is, since charges were filed against mom, is that a noli prosequi was later filed in mother's criminal case. And what that means is that the prosecutor is acknowledging to the court that they're abandoning their charges for prosecution. So they're abandoning the whole claim, so it's like it never existed. So within a week, the children were returned home. This case was upheld by the CANRB, and the investigator found that the boyfriend physically abused child and neglected the other 3 children, and that mother neglected each of the 4 children by POE. So we're at the circuit court based on mother's appeal of the POE. And they based that on physical injury to the child at the time of the report, the medical records, the statements, and on the physical condition of the home. Please note that this was this happened in 2007. So this was prior to the conclusion form we're now required to use. So the question to you is, did mom jeopardize child safety by allowing the boyfriend into the home after his prior domestic assault case where mom was a victim? I think the more successful argument in this case appears to be that mother was not neglectful. She was unaware of the abuse at the time of the incident. There was no prior history that he was a perpetrator of abuse to her children, or that mother or the Children's Division had any knowledge of it. She took immediate action to protect the child once it was discovered. She cooperated fully with authorities. Her kids were returned in a week. Her criminal case was dropped by the prosecutor. And even if you could make the argument that the one child had been neglected by mother, the one that had been injured by the perpetrator, there was no grounds for finding of neglect with regard to all 4 children, 2 of whom were not even in the home at the time it happened. So this is one of those cases where a circuit court case is filed, and in the process, an agreement is reached between the perpetrator and the Children's Division to settle the case. And I believe that is what has happened in this particular case, and the mother's name came off the registry for neglect. Well, let's take a look now at activity number 3. We continue in the neglect realm. The directions in this particular case is you're looking at a circuit court case for de novo judicial review. Please read the judgment. Would you find that the legal elements of neglect were met and that mother's name should remain on the central registry? One of the things I really want for you to take a look at is the wording that is used in terms of neglect. What words did the court use to talk about the concept of neglect when applying it to the facts of the case? This was a very complicated case. The mother is underage. There was a lot of other things that were going on in this particular case. Most of that was edited out, and I really would hope that you would just hone in on the neglect and take a really good look at neglect in this case. So we're going to stop the tape at this point and give you a chance to read activity number 3, discuss it with your friends, and then we'll get back and, like Heidi Klum says, we'll have a little chat about it. All right, let's pick back up on activity number 3. Clearly, if you've looked at the end of it, the court does uphold our findings. The court affirmed the findings of Children's Division and the CAN Review Board, and mother's name remained on the central registry. So that's a great thing. Like I said, this case was heavily edited in order to just focus on the neglect of the case. So again, the court starts out with its findings of facts and conclusion of laws and judgment. It talks about who the parties are and how the court is making a finding of preponderance of the evidence, and then they get around to the facts of the case. So mom's underage and has a child. The child, mother was about 17. She lived in one city, went to visit relatives in another city, had the child with her. The child was probably about a year or so old at the time all of this happened. Well, mother met up with one man in the city and he asked her if she and the child were willing to be pimped out. And at that point, mother declined to be pimped out. This is what the court found to be true. But she continues to socialize with this guy. So at some point within the next 2 weeks, mother allows a young adult male named Ammo to take the child for about 4 hours to an unknown location. She doesn't know him. She just met him that day. She was later informed that he attempted to have sex with the child. Mom did not report the allegations that Ammo had attempted sex with the child to law enforcement or otherwise seek a medical evaluation of the child. So mother continues then to hang out at Carlo's house, and mother ends up performing oral sex on another friend of Carlos's, goes by the name of Red, while she held the child in her arms. Eventually, this ends up in a hotline situation. The police department gets it. Mother and child come into emergency protective custody. So I think this paragraph 11, has a lot of specifics in it that go to the neglect. And I think with neglect, sometimes it takes a lot of specific. If you're going to put somebody's name on the registry, number one, because of a severe diaper rash and the fact that it was untreated, then you need to really be able to show dramatically how serious that diaper rash was. And I think in this particular case, the court talks not only about how serious it is, but the amount of pain that it caused the child. So when they get to the hospital, the physician finds the child's diaper saturated with liquid feces and urine. It was clear the mother had not changed the diaper for a significant amount of time, probably over 8 hours. When we talk about neglect cases, I always try to remind people that time is very, very important in neglect cases. In any type of neglect, you want to know how long did this go on. And anytime you can get a period of time, I think it really helps you show whether there was neglect or not. So here we've got probably over 8 hours. The court found probably over 8 hours. The physician found that her entire diaper area was covered with a severe diaper rash. Mother said she didn't like changing it, and a preponderance of evidence establishes that mother failed to change the diaper as often as was required to maintain the child's health. So you go back to, this is one of those adequate basic care cases. The parent has to provide adequate basic care. The parent has to change the child's diaper at a minimum for their health and well-being, and the mother failed to do it. The evidence establishes that the diaper rash was painful to the child and required medical attention. So now we have untreated illness or medical condition, right? Here we go. The child has this severe diaper rash that required medical attention, was painful to the child. This is something that the parent should have taken the child for treatment and did not. The court finds that the mother was aware the child had the diaper rash for several days. So it's just not how long was the child in the diaper, but how long had the child had the diaper rash, and failed to change the diaper as often as reasonably necessary to meet the child's basic needs. You'll see the term reasonably used throughout this a lot. In many ways, reasonably would be an opinion of the court in doing this, of what they considered to be reasonable. I think if you can show how long the parent goes without changing the diaper, how severe the rash is, and how long the child is left untreated, that allows the court then to make the decision that it was unreasonable amount of time. So mother either knew or should have known that the child had a diaper rash which required medical attention. I think that's very, very important. So now I'm going to take a look at the conclusions of law that the court set out in this case. And of course, in paragraph 15, the first thing the court does is set out the legal definition of neglect with the 3 elements that are included. And then the court starts talking about, does it have the information for each of these? If you look on paragraph 16, mother is the child's mother. She had actual physical custody of the child at the incidents in question. So you've got her either way as being responsible for care, custody, and control. 17, the court kind of frames what type of neglect it is. Mother failed to provide the appropriate medical care for the child. Again, the court uses the term unreasonable. You could say mother should have sought medical treatment in a reasonable time, but mother unreasonably failed or attempted let's see, mother unreasonably failed to seek medical evaluation and or care for the child after she was told that Ammo may have attempted to have sex with the child. And then mother failed to take the minimally necessary steps to treat the child's diaper rash, such as changing the child's diaper when it needed to be changed and to obtain appropriate medical treatment for the child's severe diaper rash. Number 18, let's look how the court termed neglect in this particular way. Mother failed to provide other care necessary for the child's well-being. Again, they're using the term out of the legal definition of neglect. Mother unreasonably failed to change child's diapers as often as necessary for child's well-being, which caused child to develop a severe and painful diaper rash. So severe and painful, I think that's very descriptive. B, mother unreasonably failed to exercise appropriate supervision of the child by allowing a man who she had just met and did not know to take the child for several hours to a location unknown to her for an unknown purpose. So I think that clearly sets out what was going on. Mother further failed to provide other care necessary for the child's well-being when she failed to seek a medical evaluation of child after she was told Ammo had allegedly tried to have sex with the child. Since there's no medical findings or anything confirming any of that, I assume that's where that part ended. This conduct unreasonably placed the child in a situation in which the child was at an unreasonable risk of being sexually abused or neglected. So I think what's really important in that statement is that mother placed the child in a situation in which the child was at a high risk of being sexually abused or neglected. The child was at a high risk. I think that's a very important thing that we can say. C, mother unreasonably failed to exercise care necessary for the child's well-being and exposed the child to, again, a high risk of harm, including a high risk of being sexually abused, when she chose to socialize with a man who offered to pimp her and the child out for money. And then lastly, mother unreasonably failed to provide care necessary for the child's well-being when she engaged in oral contact with Red while holding the child and put the child at an extreme and unreasonable risk of being sexually abused and being exposed to sexually transmitted diseases or physically injured when he ejaculated on the child. So again, this is another one that was upheld at the CANRB. I think it's the way that we look at neglect. Again, placing the child at a high risk of harm is part of the neglect piece. The case TJ says that the child doesn't have to be harmed. The fact that the child is placed at a high risk of harm is enough. So that's activity 3. At this time, we will move on to the legal element that's in both abuse and neglect, and it's the one called those responsible for the child's care, custody, and control. We have 3 slides on this, which is mostly the legal definition of responsible for care, custody, and control. So it's a legal definition, and what I want to point out to you is that if the perpetrator meets the legal definition, he may not have to have actual care, custody, and control. And I know the reason for this part of the training is that over the last year, I've had multiple requests from circuits to take a look at some of the cases that have been sent to the field because they're saying, why are we getting these? This person doesn't have care, custody, and control. And I've had to go back to this definition to explain why they're getting them. So we're going to take a look at about 3 of those cases. So who is responsible for care, custody, and control? Let's look at slide 20. It's a parent. It's a legal guardian. It's other members of the child household, and the division in policy requires that they be responsible for care, custody, and control. It's someone exercising supervision over a child for any part of a 24-hour day. So that could be a babysitter, that could be daycare, that could be a teacher. In most cases, we're looking for some sort of explicit authority to exercise care over the child for any part of a 24-hour day. And the one that really has gone to most of the cases that I've been asked to look at is slide 21. And that's the adult who has access to the child based on a family relationship. So it's an adult who has a relationship with the parents of the child, an adult who has relationship with members of the child's household, or an adult who has relationship with members of the family. So let me say it again. This type of adult has a relationship with the family and has access to the to the child. They do not actually have to have care, custody, and control, but that is enough to say that they meet the legal definition of responsible for care, custody, and control. Let's take a look at 3 cases that will help illustrate those responsible for care, custody, and control that actually do not have care, custody, and control. The first example involves mom and a dad and a small child. And mom has a friend from high school who's recently got out of prison. He's on the sexual offender registry for felony sex abuse of a child, but he's convinced mom that it never really happened, it was all a mistake. So he comes over quite a bit, and he's in the home with mom and dad and the child. Well, one day, mom goes out to the grocery store, and the gentleman is in the home with dad and the child, and dad is fixing dinner. The child goes up to his room, and guess what? This friend of mother's goes up to the room too and sexually abuses the child. So does he meet the definition of care, custody, and control? Number 1, he's not a parent. Number 2, he's not a legal guardian. Number 3, he's not a member of the child's household with care, custody, and control. Number 4, no, he's not exercising supervision over a child for any part of a 24-hour day. But he is an adult who has access to the child based on his relationship to the family. So that in and of itself is enough for you to be able to make a finding on this type of person and put their name on the central registry. Here's another example. A female child is around 12. Her brother's over 21. His friends, the brother's friends who are over 21, come around the house a lot. One of the friends drives up alongside this 12-year-old girl as she's walking home from school and offers her a ride home. He then drives across state lines and rapes her. Is this a case where we could make a finding of sexual abuse and put his name on the registry? Let's go back and look again at the legal definition of care, custody, and control. This friend of the brother who's over 21 is not a parent, he's not a legal guardian, he's not a member of the household, he's not exercising supervision over a child for any part of a 24-hour day, but he's an adult with access to the child based on the relationship with the family, meaning with the brother. But for this man's relationship with the brother, the child probably would not have gotten in the car. So he fits the definition of responsible for care, custody, control, and his name can go on the central registry. Let's go one further on that particular scenario. This friend of the brother's has another guy with him in the car that the girl does not know. He is in the car when it goes across state lines, and he also rapes this girl. In that particular case, it is purely a criminal matter and not a case that we can do anything about. The brother's friend fits the definition of responsibility for care, custody, and control. This friend of the friend does not. He did not know the girl. He did not have access to the girl based on his relationship to the family, so it doesn't work for him. Lastly, this is the third example. Mom and her 14-year-old son move in with the boy's adult sister. So the adult sister has a good friend who lives next door with her husband and a couple of small children. There's lots of visiting back and forth between the two homes while mom and her 14-year-old son are living with the sister. A lot of times this goes on when mother is not around, meaning mom's working. The adult sister gets suspicious and confronts the child, who admits that he's having sexual relationships with her best friend who lives next door. The adult sister then confronts the neighbor, who admits to it and then later denies it. The adult sister tells mom and what she said. Mom hotlines it about, and the neighbor's husband calls and suggests the boys should be tested for transmittable diseases. So does the friend of the adult sister count? Well, number one, mom and the 14-year-old boy are living in the adult sister's household, so they're all living there together. The friend of the adult sister is not a parent. She's not a legal guardian. She's not a member of the household. She lives next door. She has no explicit supervision over this child. But she's an adult with access to the child because of her relationship with the adult sister. The adult sister had seen some suspicious acts on the couch. Maybe they had been a little too close together, and the boy had she'd found the boy over at the next door neighbor's house on one occasion, and I think that was part of that. So in all three of those cases, they do not have actual care, custody, and control, but they actually meet the definition of that. Let's talk about weighing evidence. In other words, who do you believe and why, and how does that help us meet our burden of proof by a preponderance of the evidence? I think what happens a lot in investigations is that there's a whole lot of information from a whole lot of different people, and a lot of it is conflicting. And sometimes it's a matter of sitting down and sorting through the evidence and trying to figure out who you believe and who you don't. And some of it you have to do timelines on and try to rule information in and out and look for other witnesses. But sometimes it just really comes down to the statements that are being made and whether or not those will give you enough evidence that the child has been abused or neglected. So we're going to start with activity number 4. And this is a circuit court judgment, and the judge spends a lot of time explaining how he believed who and why. And I will tell you in this particular case that he comes to the conclusion that he can't make a decision either way on who to believe. And consequently, we have not met our preponderance of evidence, where our side that the child had been abused weighs more than the fact that he had not. But the court goes into great detail to explain that. So what we want you to do is take out your activity number 4 and read pages 1 to 5 of the court judgment. The allegations are 9 or 10 years old when they were investigated. You need to know that. So there's a lot of facts in here that talks about what was going on and who knew what and how people knew what, and ways of corroborating it or not. So you want to take a really hard look at the facts. Having done so, you decide whether or not you would find there was enough to make a finding of sexual abuse and leave this person's name on the registry. Then I want you to read the rest of the judgment to see how the judge weighed the evidence and why. So we'll stop the tape right now, give you a chance to read the case. This one will take you a little while. And like I said, read pages 1 through 5 and talk about the facts and where you think you are. And then take the time to read the rest of the judgment and see how the judge came to his conclusion. Okay, you've had a while to take a look at activity number 4. Let's talk about it a little bit. There are a lot of findings of fact in this particular case. And I think what we're going to take a look at, really, you've looked at all the facts and have made your decision on what you believe. But I think we need to look at the legal conclusions and discussion. And this will give you a perspective on how judges make decisions about how they believe, what they believe, and why. So the court believes that resolving this case in great part depends upon evaluating the testimony of 4 witnesses: the child, the perpetrator, the mother, and the therapist. And lastly, the court must judge the credibility of the witnesses. And credibility goes to who you believe and why, both individually and as a whole. And that's kind of what you do with preponderance of evidence. You want to find whether or not you have preponderance of evidence on each of the parts of the evidence and whether or not as a whole you have preponderance of the evidence. So the court looks, I think, at the interest of the witnesses and the outcomes of the case. So what are we talking about? Mom appears to be a credible and thoughtful witness. Obviously, the case involves her child, and at least indirectly his welfare. So her testimony, he has to take that into consideration and how much he's going to believe her testimony. In the same vein, the therapist was a believable witness with notable expertise and background in the area of child psychology and abuse and neglect. But the therapist also has some interest in the case, as he's been the personal therapist of the child for an extended period of time. The court also heard the testimony of the perpetrator. He's now married, adult with children. He also appeared to be credible and thoughtful to the court. It goes without saying that he too has an interest in the outcome of litigation because it will affect his livelihood for the rest of his life. The child appeared to be a sincere witness that presented a reasonable demeanor and in general described the acts of abuse. And I think in general described the acts of abuse. You need to think of that term in general. He admitted the delay in reporting of the abuse of these allegations, and he admitted his prior denials. So where's the court going? What's the court going to use to make up its mind? The court looked at the civil jury instructions and the criminal jury instructions. And those are the instructions the court gives to the jury in a civil or criminal case. So they're in reasonably plain English on how the jury should look at the testimony. So under the criminal jury instruction, in determining the believability of a witness and the weight to be given to the testimony, you may take into consideration the witness's manner while testifying. Manner while testifying. Do they hesitate? Are they unsure? Are they very clear about their answers? Think of all the specifics when they're testifying. And that carries into our cases because think of how the persons tell you their story. Are they clear? Are they hesitant? Can they not give you detail? Does their body language indicate to you that they're not telling the truth? Secondly, the court looks at the ability and opportunity of the witness to observe and remember any manner about which testimony is given. So sometimes the memories are not clear, but sometimes the memories are very clear. So if a person is giving very clear testimony with a lot of detail, the court is more likely to believe that. And again, in our investigations, if you have a child who's giving very believable and very clear detail about what happened, that will make them more believable. Now, does this work with our little kids? No. But when you have the older kids, the detail, I think, really matters. The judge also draws our interest to any interest, bias, or prejudice the witness may have. You know, what does the witness have to gain in their testimony and the outcome of the case? Next, the court asks the jury to look at the reasonableness of the witness's testimony considered in the light of all the evidence of the case. So how reasonable could it have happened that way? Based on all the other facts in the case, could it have happened that way? And any other matter that has a tendency and reason to prove or disprove the truthfulness of the testimony of the witness. So that's what the criminal instructions told the judge. The civil instructions provided the judge with some information. It suggested, considering the weight and value of the testimony of any witness, you may take into consideration their appearance, attitude, and behavior, the interest, here we go, kind of the same thing, in the outcome of the case, the relationship of the witnesses to any parties, and the inclination of the witness to speak truthfully or untruthfully, and the probability or improbability of those statements. So where did the judge then go with how he decided what happened? In the next paragraph, he says, if this cause were to turn solely on the impressions of the witnesses, resolution of the matter would be difficult, to say the least. So the court must consider factors that are routinely used in assessing credibility and the weight of testimony. So again, I think these are ones that we need to consider when we're doing investigations too. Child in this cause waited over 8 years to lodge these allegations. He denied them on multiple occasions, and on at least 2 occasions, mother inquired of her son regarding concerns of abuse, and child denied the same ever had happened. The therapist, as a professional experienced in these matters, failed to reach the conclusion of abuse after 2 years of therapy. It was only after the delayed disclosure by child that the therapist reached any kind of diagnosis regarding the abuse. At the time of the alleged abuse, and I think you want to consider this, at the time of the alleged abuse, child's family was going through a difficult family situation in which child's father basically left the household. Perpetrator has consistently denied these allegations and chose to testify on his own behalf. I think also there was another babysitter that talked about some stuff that was going on in the house prior to the perpetrator becoming the babysitter, and I think that might have had a little bit of an effect too. So considering all the evidence and the reasonable evaluation of its weight and credibility, the court simply cannot make a finding that it is more likely than not that the perpetrator was the perpetrator of abuse. So the court can't say that there's more evidence that weighs in favor of this person be a perpetrator of abuse. And without being able to say that, therefore they cannot uphold our finding or that by the Can Review Board. The court hastens to say that this judgment should not necessarily be considered as questioning the integrity of any witness, but is a statement that the court believes the evidence is at best in equipoise, which means equal. Thus, the law requires a ruling in favor of the perpetrator. So that's the end of that case. Now I've got 2 slides, I think 24 and 25, where we talk a little bit about credibility and weight of evidence. And this might be something sometime that you supervisors might want to do with your investigators. Take a look at credibility and weight of evidence. Think about the appearance, attitude, and behavior of the witness. Okay. Again, how are they talking about it? Are they comfortable? Is their body language that they're not telling the truth? Are they very vague in what they're talking about? Are they having difficulty recalling the information? So it calls into question whether or not you think they really know what they're talking about. The interest of the outcome of the case. I think that's very important to rule out, especially in sex abuse cases involving kids and physical abuse, especially with our teenagers. Does the child have an interest in the case? So the particular outcome. Does the child want to live with the other parent? Is that why they're saying sex abuse? Does the parent not like the particular parent they're saying abused them's rules? Is the child jealous of the step-parent or paramour relationship with that parent and wants them out of the house? Don't forget that sometimes the reason the child isn't telling the truth is because, or part of it is not true, is because they don't want to get in trouble with their parents. Maybe someone else is the perpetrator, but they did something they weren't supposed to. Like number one, they were at somebody's house they weren't supposed to go over and stay at, and that's where it actually took place. Or they were driving somebody else's car, or it happened in somebody else's car, or they were with somebody they were not allowed to be around, and that if they tell the truth on that part of it, they're liable to get in trouble. Again, I think when you go back and clarify things, if you can talk about that with the child and document it in the investigation, the sex abuse can still be believable if you can clear up that point on why the child doesn't want their parent to know the truth. Interest in the outcome of the case for a parent. Well, if his or her child is the victim, it had to have happened, right? If the child says it had to have happened. Maybe this particular parent wants custody of the child, and that's why they're making the statements they're making. Maybe this parent doesn't want the other parent to get custody of the child. Maybe this parent wants to get even with the divorced parent for some reason. Maybe this parent is making the statement they're making because they don't want to lose their spouse or paramour because of the child's statements. Maybe they don't want to lose their job as a teacher or doctor, and that's why they're not telling the truth. Maybe they don't want their neighbors to think that they're a bad person for some reason if they know about it. What about a foster parent? Does a foster parent have an interest in the outcome if they're an alleged perpetrator? Well, they don't want to lose their foster parent license or the income that goes with it. They don't want to lose the ability to adopt the child. And there was one case at the CanRB where part of the problem with the foster parents is that they were getting ready to adopt a number of children, that, two of which weren't related, and they were both teenagers. One was a girl and one was a boy. And it turns out that they were playing boyfriend and girlfriend and having sex, and the foster parents that were willing to adopt them knew about it. Well, the kids held that over their head and said, if you don't let us do what we want, then we're going to tell the worker that you knew about us, having sex. So there was, that goes to that interest in what was going on in the case. When you talk about credibility and weight, you look at the relationship to any of the parties. What about grandma or grandpa? It's his adult child or her adult child that they don't want to see end up as a perpetrator, so they may not be truthful. They want custody of the child. Likely to tell the truth or not. Consider whether the adult or the child has a history of lying. Does the adult have multiple criminal convictions? Has this child or adult told different versions of the same story? Does this child or adult have a reputation for lying or making things up? And think about that. And then the probability or not of any of the witnesses' statement. Again, could it have happened that way? Why do you believe it didn't? What other facts do you have that you can say it didn't happen that way because blah, 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 and then state the reasons for it? I think sometimes in our investigations and conclusions, it's not just about the facts, it's about the reasoning that goes along with the facts. So I think with credibility and weight, this gives us some guidance and what to look for when we are trying to determine truthfulness in what happened. On slide 25, we talk about credibility as believability, and weight is the importance you give to each piece of evidence. So I think evidence weighs more if it comes from someone who made a first-hand observation of what happened or what was said or what the bruise looked like. Weight is also the value of all the evidence on one side against all the evidence offered on the other. So you put all the different pieces of evidence together and overall which weighs more. And for a can finding by preponderance of the evidence, we know that the evidence for child abuse or neglect must weigh more than the evidence against it. At this point, we're going to move on to what I call potpourri. And we're going to talk about maltreatment. This is the last part of the training. I want to look at a couple of writing examples and look at the marvelous use of words by the investigator in whatever particular case it was. I want to look at an OHI investigation because of some words that were used. I want to talk for a few minutes about the burden of proof and differences in juvenile and criminal cases in CAN, and I have an example for you. And I'd like to close with interviews with some of the investigators and up their chain of command in Greene and Jefferson County on what has worked well for them in their investigations and at CAN-RB, because in the couple of quarters of 2010, they just had marvelous uphold rates, which means that they're doing really good work. Okay, first off, we're going to talk about the word maltreatment. The word maltreatment is out of policy. So instead of sexual maltreatment, policy now says sexual abuse. Instead of emotional maltreatment, policy now uses the term emotional abuse. So it's important to know that that is in the conclusions that have to be used. We know there are changes coming to the CS21 to make that piece work also. But the term maltreatment is out, the term sexual abuse and emotional abuse is in. Those match up with the legal elements of abuse, and it's very important that we learn to use those terms. Okay. Secondly, let's take a look at a writing example. And again, I want to let you know that these are investigations for various reasons, sometimes that come by my desk. These are not circuit court cases. These are investigations that I've either seen at the CAN-RB or for some reason I've looked at the investigation and I just found some little gems in the investigation that I thought were worth talking about. So we're going to talk about what I thought was a writing example. And what's important to me is it shows the reasoning of the investigator on how she decides this is not abuse. It illustrates her thoughts on unusual but not unreasonable discipline, which I thought was interesting. It illustrates the technique of asking the alleged perpetrator to demonstrate the discipline technique. And I think that's an important thing to do. So at this point, let me read a little bit about what we have. The allegations that came in were that Dad was sitting on his 7-year-old son, child, and pulling his arms. So the investigator met with the family. The investigator talked to Dad about his version of the events. He began by saying that the child was assaulting him. What was he supposed to do when the child was attacking him? What about parents' rights? He appeared anxious and defensive. The investigator talked to him in a calm manner and told him she just wanted his version of the story. She also said that it was apparent to her that the child was difficult to manage. He appeared to calm down and described what happened. Dad said the child had been throwing toys and physically abusing him, meaning Dad, and he couldn't get child to stop. He said he put child on the couch, and then Dad sat with his legs over child to keep him immobile. The investigator asked Dad to demonstrate this for her. This all came straight out of the investigation, you guys. Dad sat on the couch in a normal fashion and indicated that the child's legs were underneath his knees. As Dad is a very thin man, and as only his knees and thighs would be resting on child's body, the investigator felt that this was permissible, even if not typical, for common punishment or restraint. So she's explaining to you why. She had him demonstrate what he did. She observed how thin he was, how he really wouldn't have been able to hurt the child in this. The investigator then asked Dad what child meant when he said that Dad was pulling the child's arms. Dad said he showed the investigator that he would take both of child's arms in one of his and hold them together so the child could no longer hit or throw things. The investigator then asked child to see the wrist to see if there were any visible injuries from Dad holding the child's wrist. The investigator stated that she saw no injuries and that, although not entirely appropriate, she did not feel that this was any way abusive. The child yelled at Dad, "You're not the boss of me." Well, the investigation and the report continues, and obviously it was unsubstantiated, but you can see the investigator's reasoning. There obviously are parenting issues here and services that are needed. I just thought that was a very interesting way to talk about it, and the fact that she asked Dad to demonstrate what was going on. So I thought that was a pretty good one. The next one is another writing example, and this one is really pretty short. The boy is 14 and the girl is 11, and they came into protective custody for neglect. Among other things, they were locked in a bathroom for discipline and deprived of sufficient food as discipline. So we're going to kind of narrow what we talked to about the neglect for lack of food. So this is what was in the investigation. The boy and the girl were evaluated by medical professionals on November 25, 2009. They were found to have very low body fat and found to be in the 0 to 5th and 10th percentiles for their height and weight, respectively. The children were reevaluated on November 30th and December 18th, 2009. In 23 days, the boy had gained 13 pounds and the girl had gained 7. Let me say that again. In 23 days, the boy had gained 13 pounds and the girl had gained 7. Their pediatrician diagnosed them with child neglect. That always helps. The doctor stated that the child's weight, body mass, and their statements of having restricted access to food was consistent with physical and nutritional neglect. He further stated that the rapid weight gain was indicative of nutritional neglect, which he stated is the fundamental lack of proper nutrition and calories for proper growth and development. I just thought that was a great paragraph, and the fact that the doctor had stated what nutritional neglect was, because I think that helps you with understand what is the parent supposed to provide in a neglect case and what did they fail to provide. Well, what's the parent supposed to provide, at least as far as the nutrition goes? Nutrition and calories necessary for proper growth and development. And they obviously failed to do so based on the doctor's statements, and then that marvelous description that in 23 days the boy had gained 13 pounds and the girl had gained 7. So to the investigator in this case, very well written. Let's now look at an OHI case. And this is an older case, so the summary is written a little differently, but I just thought it was interesting, and the fact that sometimes those common sense observations that you can make are very important to your elements of abuse and neglect. In this particular conclusion, the OHI investigator set out the Chapter 210 definition of physical injury, physical abuse, and of neglect. And then he set out the facts that support his conclusion. The teacher was 39 years old, and the child in this case was a student in his class. The child went up to the teacher and grabbed his pens. The child and the teacher were laughing about it. The teacher reported that after a couple seconds, he realized they weren't playing. The child reported that the teacher grabbed her by the elbow and twisted her skin. Other students reported that the teacher twisted the child's arm behind her back. The students also reported that at that time the teacher did not look like he was playing anymore. One student reported thinking that the teacher was going to break the child's arm. The other students and the child reported that the child had said to the teacher to let her go because he was hurting her. Now you have to remember, she had a hold of his pens and then he grabbed a hold of her. The teacher reports that the child was saying something but didn't know what she was saying. The teacher reported he grabbed the muscles on the child's neck and applied pressure. The child had on foam flip-flops. The child reported she kicked the teacher in the shin in an effort to make him let go. So she's at a point now where she can't get out of the hold. He's the one that has control. And this is the child's version. The child reported that the teacher still didn't stop twisting her arm. The child reported that the teacher kicked her back. When she kicked him with her flip-flop, he kicked her back. She then reportedly kicked him again. She reported that the teacher kicked her again in the groin area, and then he finally let her go. The teacher's version was that the teacher reported that the child kicked him and he kicked her back. The teacher said he was protecting himself and defending himself. And I want you to remember that statement because it really looks a little different than that when we get to the absolute conclusion. The child went and reported the incident. The school nurse examined the child. The child had red marks and an open area on her vagina. The child had a scuff mark on her leg and a bruise. The police and the school nurse documented the injuries. So when the OHI investigator wrote the conclusion, he said there was sufficient evidence to support the allegation of abuse. The child is under the age of 18. Teacher had care, custody, and control because he was a teacher in the school district and this was a child in his class. The teacher caused injury to the child during discipline. The teacher reported he acted in self-defense, but the teacher weighed 150 pounds more than the child and was 15 inches taller than her. So remember, he was talking about he was acting in self-defense. The teacher is an experienced teacher. The teacher twisted the child's arm and kicked her. The child wasn't being aggressive with the teacher when he twisted her arm and applied pressure to a pressure point. After the child told the teacher he was hurting her and told him to let her go, he didn't let go. The child kicked the teacher in an effort to make him let go, and he kicked her in the shin and vagina, which resulted in injuries. Therefore, there's a preponderance of evidence that the teacher physically abused the child. I thought that was, the height and weight are very, very good. This man weighed 150 pounds more than that child, so tell me it was self-defense. The descriptors were great. It paints a picture of the fact that these were unreasonable actions of the teacher. The other thing that really draws a point in this case is none of this had to happen. All the teacher had to do was let go of her and initially let go of the pens, and none of this would have happened. So that's the moral of that story. And I think sometimes those are the common sense things you need to put in your investigation when you're talking about coming to the elements, was all he had to do was let go of her, and he chose not to let go of her. We're down to 2 more things, and then this training is over. We want to talk a little bit about the difference between a can finding and criminal charges in juvenile court adjudication. The example I want to use is a case where the mother's paramour stuffed the child's mouth with socks, grabbed her by the hair, held her under the shower under cold water. He also put her in an oven and threatened to turn it on. The child's siblings had witnessed these events and were able to corroborate the child's story. So how did the 3 systems work across themselves? Let's look at the criminal system first. I think that's a pretty easy one. If you look at section 568.030, entitled Abuse of a Child, that's a criminal charge. A person commits the crime of abuse of a child if such person knowingly inflicts cruel and inhuman punishment upon a child less than 17 years of age. I think clearly the facts would show that that happened in that particular case. Is there enough evidence for juvenile court jurisdiction? Well, this is the mother's paramour. You need to know what the mother and father are doing. And if the mother's failing to protect and you've got no father around, something along those lines, then juvenile court jurisdiction might be established under 211.031.1, paren 1. And the basis for jurisdiction is that the child is in need of the care and treatment of the court because the child is otherwise without proper care, custody, or support. Otherwise without proper care, custody, support. So this would be a case where you may not be able to show physical injury or have abuse, but the basis for jurisdiction does not require that. That would be a pretty scary scenario. And the fact that if he got mad enough, all he had to do was turn the oven on, that had to be very, very scary. To me, that would be a case of imminent danger where a child could come into protective custody and you could easily meet the child is otherwise without proper care, custody, or support. So now let's look at our system. Our Chapter 210 definition of abuse requires physical injury, sexual abuse, or emotional abuse. And then the other four elements are required. Inflicted on a child other than by accidental means, by a person responsible for care, custody, and control, except discipline administered in a reasonable manner shall not be construed as abuse. Well, let's just take a look at that first element. Do we have sexual abuse? No. Do we have physical injury? For a physical abuse case, we have to have physical injury. We do not have physical injury in this case. Do we have any facts that would give rise to emotional abuse? To make a finding for emotional abuse, you have to meet the state versus Moran requirement of injury to the child's cognitive or psychological capacity, as demonstrated by anxiety, depression, withdrawal, etc. So you have to be able to connect the dots between the outrageous thing this paramour was doing to changes in the child's psychological capacity or well-being. And in this particular case, we don't have enough evidence. So this is how these cases work sometimes. There are just some situations where we can't make the elements of abuse match with the outrageous conduct that's going on, even though there's enough for juvenile court and imminent danger to remove a child, even though there's enough for a criminal conviction in the case. So just a reminder that sometimes those don't always match up. Lastly, let's talk about some conversations I had in Jefferson County, with Jefferson County and with Greene County, because I looked at a couple quarters of the CAN Review Board statistics on the number of cases, and they were having outrageous amounts of cases for a quarter, something like 15, 17 cases before the CAN Review Board in a 3-month period of time, and they were having outrageous uphold rates, which means they were doing something really, really well, and I think they should be complimented for that. So I had a conversation in January of 2011 with Heather Ford about those fourth quarter statistics at the CAN Review Board. She said, I asked her, what has changed or what makes a difference in your success rate? Why have things gone up? So we talked about a number of things, and she says they now attend the CAN Review Boards in person. They think that makes a difference. They feel like they have better success. If it's a critical or complicated case, they're sure they go in person. They involve the CAC. Sometimes they take them as a witness, or they have them on the phone, the forensic interviewer or the nurse practitioner on the phone. If it's something very important that they think there might be questions on, then they want to be able to provide that person to provide the detailed information. So I think you pick your battles on who you take, but you have 20 minutes, and the Children's Division does not always use up their 20 minutes on their presentation at the CAN Review Board. I think the prosecuting attorney was on the phone one time, didn't file the charges, had a strong opinion, felt it met our standard though, and wanted to make sure that CAN-RB understood. So I think support from their community is an important thing. Sometimes they bring in police or the detective that's involved. The biggest thing she said that they've changed since '09 is they have pretty elaborate discussions before they make the preponderance of evidence finding. They're weighing all the possibilities, and they talk about how you're going to explain that. They also play devil's advocate. They argue it out. So they, if you were the perpetrator, what would you say to this? How would you counter this argument? So they actually take the time to try to look at both sides of the elements. When you're doing that, you're looking at both sides of the elements before you're making conclusions. She felt that the workers had gotten good at writing their conclusion. And like we said earlier, they try to troubleshoot. Take a look at where the problems are before you get to can or be, and that you've got them documented. And a lot of it, she said, is thought process. Other things that she talked about, it's her expectation that the devil advocate stuff be done. Here are the excuses the perp will make at can or be. That's her expectation, that they're going to look at that other side of it, and I think that's a great one to set. Realizing that you can gather and present additional information at the can or be just like the perp does. Sometimes there's information that comes up afterwards. At this point, everything's open, I think, for the can or be presentation. Also, discussions with the AC workers so they have additional information before they go. I think I've said many times, if you're presenting at can or be and there's a protective custody affidavit in there or an order for removal of the child, you really need to find out from the AC worker what's going on with the case, where the child is placed. And in some cases, sometimes you have the AC worker on the phone or bring them with you so that you know what's going on. Because I think sometimes the can or be is going to ask some questions. Is it necessarily relevant to their decision? But sometimes they're just caring people and want to know what's going on. Who does a really good job of all of this? She said Betsy Burroughs, who's now an investigative soup, and that Dana Klusner has had a couple upheld and has done a really good job. I thought those were important to let you know. She says too that they talk about the purpose of the central registry. Sometimes when they're trying to decide whether they've got enough for the case, are they doing it just to protect other kids, not to punish someone? The idea is the whole purpose of the investigation, if you make the finding, is to put somebody's name on the registry. She talks about creating an environment for a friendly little debate, laugh a little. Sometimes you get stuck. Sometimes you feel like smoking. But if you can string all the facts and the details together, you paint the pictures. And sometimes what it boils down to is connecting the dots. And I would agree with that. I've read lots of Greene County investigations, and they're usually very, very detailed investigations. So they've got the information to counter any argument that the perp is going to make. And that's really a good investigation, looking at both sides of the case. I also talked to the folks at Jefferson County, and this was a group conversation. They said, why are they doing so well? Number one, at the can or be, they write out their presentations in advance. They write the facts to the elements, and they're doing thorough investigations. And I've got 4 exclamation points after that. So I think that they thought that was really important. What did they mean by more thorough investigations? They said everything is documented. They go over it. They meet the elements. If they've got physical abuse, they're looking for doctor's affidavits, statements from everyone in the house as far as the ones they know who they are. On sex abuse, they interview them at the CAC. They rule out motive to lie. They're very specific about what the child was wearing, what time of day, specific information, any that you can find that will help corroborate what is going on. They'd been through finding words, and they thought that was really, really important. They try to find out who did the child tell. They try to maintain consistency. They look at the relationship between the parents. They look at credibility. I thought that was really interesting. They look really hard at it, and then they follow up with evidence. We talked a little bit about meth labs and the relationship between the perp and the victim. They're looking at that too. The most important thing that they came back to was the fact that their investigators had had finding words training. It was a course designed for sex abuse, but they felt it applied across the board in just the way they were talking to the children. They also had very consistent staff. There'd been a supervisor for 7 or 8 years. So stable supervisors, even if there's worker turnover. They require the CAN training for all investigators. They role play for workers to interview the children. They have an injury report worksheet, where on the body, size, shape, etc. And they make a point in physical abuse cases of getting photos. Since they've all had the finding words, and part of the reason that's important is because the attorneys use that when they question them in court. They don't usually go to the CAN-RB in person. All I can say is to the workers in Greene and in Jefferson County, as well as workers across the state, especially from the investigations we've taken a look at to keep up the good work and keep making good conclusions, writing to the legal elements of abuse and neglect. Thank you for your time.